Hi everyone, welcome back to my YouTube channel. I hope you all are doing good. My name is CS Harshdeep Singh Narula and today we are going to discuss on a very hot topic right now, and that is electoral bonds. Recently in the Supreme Court sessions, the discussion about the electoral bonds is going on. However, today we will discuss about the background, not just of the electoral bonds but of the donations and contributions made by the corporates to the political parties. Because while the Supreme Court sessions are going on, honorable Supreme Court sessions are going on, and our Chief Justice of India has discussed about the 5 points, out of which we'll focus on the transparency today. From where did this particular donation part started, and what was the percentage of the donation part, and what is it now, and what has changed during so many years? We'll discuss about that. Earlier what used to happen, that there was a cap on the donations made by the corporates to the political parties, and the cap was directly related to the net profits of the corporate, that is a body corporate. That means a company should be in a position to pay to the political party. That means a company should have basic net profits so that it can pay a share to those political parties. So we will discuss about how the percentage rose from 5% to then 7.5% and then to the unlimited, and we will discuss about how and why it is vague. So earlier when the concept came in Companies Act 1956, under section 293A, the percentage was 5%, and in the Companies Act 2013, which came on 29th of August of 2013, as per section 182, the percentage was 7.5%, the percentage which a body corporate can share its net profits to the political parties. Now moving further, earlier we used to say that a company should have net profits. That is, a company should be in the position to pay. Now we say that the concept of net profits has been removed. A company can donate 100% and the cap has been removed as well. So we will discuss one by one how these changes came and when these changes came and what is the effect of these changes. We will discuss about this. Is the backstory of the electoral bonds. The electoral bonds right now, which we discussed in the beginning and which are being discussed in the Supreme Court sessions, it's all about the background of the body corporates. It's all about the transparency, and the transparency has been explained and has demanded to amend the Companies Act 2013. Moving further, we will start with the discussion of Section 293A of the Companies Act 1956, and we'll decode how and what is the difference between Section 293A of the Companies Act 1956 and Section 182 of the Companies Act 2013. So I'll read it out for you. 293A reads out as this: prohibitions and restrictions regarding political contributions. That means a cap. Prohibitions and restrictions means a cap, and terms and conditions, to be honest. Notwithstanding anything contained in the other provisions of this act. This act means Companies Act 1956. No government company and no other company which has been in existence for less than 3 financial years shall contribute any amount or any amounts directly or indirectly to any political party or for any political purpose to any person. So it says that no government company and no company which has been in existence for less than 3 years 3 financial years shall directly or indirectly donate to the political parties. So 1956 Act says that a company which has been in existence for more than 3 financial years can donate to the political parties via electoral bonds. We'll read out the point 2 now. Clause 2. A company not being a company referred to in Clause A or Clause B of subsection 1. So when it say not in Clause A, it means that Clause A means no government company. So now our Clause 2 says that a company not being a company referred to, a Clause A means that apart from a government company and apart from a company which is in existence for less than 3 years, may contribute any amount or amounts directly or indirectly to a political party for any political purpose to any person. It means that as per Companies Act 1956, as per the section 293A, it means that you can donate to companies other than government companies and to the companies which are in existence for more than 3 financial years. Moving further, it says there is a proviso, there is a proviso added to it, provided that amount, as the case may be, the aggregate of the amounts which may be so contributed by the company in a financial year shall not exceed 5% of its average net profits determined in accordance with the provisions of section 349 and 350 during the 3 immediate preceding financial years. So I'll tell you what is the crux of section 293A of Companies Act 1956. So section 293A says that any body corporate, any company which is in existence for more than 3 financial years can give any amount to the political parties. However, there is a condition: you can only give a maximum of 5% of the average net profits of preceding 3 financial years. For example, let's decode with an example. So let's say in the first year the company made a profit of 100 rupees. Then in the second year the company made a profit of 200 rupees, and in the third year the profit was 300 rupees. So the total of 3 preceding years is 600 rupees. Now the average of these 3 is what? Average is rupees 200. So as per the Companies Act 1956, that your average net profit is rupees 200, and out of those 200 rupees you can only give a maximum of 5%. That is, if your net profit is suppose 300 for the last financial year, however your average net profit is 200 for the preceding 3 financial years, that means you can only donate rupees 10 to that political party out of your profit of rupees 300 of the preceding year, and which is an average of 200 of 3 preceding financial year. So that means out of rupees 300 which you earned last year, you can only donate rupees 10. That makes sense. 1956 Act makes sense. Why do you want to donate to the political parties? Are you working for the political parties or are you working for the business? That's the case here. We will also discuss after the discussion about the section 182 and the amendments came in that, wherein the 7.5% was revised to unlimited, and we'll discuss about the quid pro quo and how the Supreme Court is discussing about that as well in the sessions of electoral bonds. Moving further, on 29th of August 2013, a new Companies Act came, that is Companies Act 2013. And as per section 182 of that Companies Act, it read as follow. When we discuss in the 293A of the Companies Act 1956, the language is quite similar here as well. So it read as follows: notwithstanding anything contained in any other provisions of this act, a company other than a government company and a company which has been in existence for less than 3 financial years may contribute any amount directly or indirectly to a political party, provided that the amount referred to in subsection 1 or the case may be the aggregate amount of which the company may be so contributed by the company in any financial year shall not exceed 7.5% of its average net profits during 3 preceding financial years. While we are discussing about the section 182 of the Companies Act 2013, which came into existence on 29th of August 2013, let's also highlight the point of section 293 of the Companies Act 1956. So the 293A of the 1956 Act was saying that a company other than a government company and a company which has been in existence for more than 3 years can donate any amount of aggregate of 5% of average of net profits of 3 years of that company. We also gave an example. Now coming back to section 182 of the 2013 Act, it says that 5% has been revised to the 7.5%. That means that any company other than a government company and a company which has been in existence for more than 3 financial years can give maximum 7.5% to any political party, and that 7.5% is the average of net profit of 3 preceding financial years. Let's decode with an example again. So for example, in the first year, the company made a profit of 200 rupees. And in the second year, the company made a profit of 300 rupees. And in the third year, the company made a profit of 500 rupees. That means for the total 3 years, the profit of the company was what? 1000 rupees. So let's make the average of it. The average of it is 333.33. Okay, so now out of this, let's calculate how much is the 7.5%. So let's suppose the company earned 500 rupees in the previous preceding financial year. However, the average of 3 financial years is coming as 333 rupees 0.33. We'll take as 334. So the maximum the company can donate to any political party or contribute is 25 rupees 0.5 paisa. So we were discussing in the 1956 also we made an example. Now in the 2013 Act we are telling you example. I'll repeat again. In the first year the company earned a profit of 200. In the second year the company earned a profit of 300. And in the third year the company earned a profit of 500. The total profit for the 3 preceding financial years is 1000 rupees and the average of 3 years is 334 rupees 334 and the 7.5% of 334 is 25 rupees and 5 paisa. This is the maximum the company can donate out of 500 rupees of the previous profits. That is all the total profits right now the company has. However, we will discuss only about the average net profits. Moving further. So now there is going to be a game changer thing. So I'll read out for you. We discuss section 293A of the 1956 and 182 of the 2013 Act. Moving further. Now the game is going to change. On 10th December 2013, a letter has been issued by Ministry of Corporate Affairs to all the registrar of companies and to all the RDs. So RDs and ROC are those people to which the returns, to which the submissions, to which the every change of the company is to be filed within a timeline, within a time limit. So on 10th of December 2013, a letter is being issued by Ministry of Corporate Affairs to all ROCs and RDs. Now it reads as follows. It is hereby clarified as, I'll read only the points. Thus, Ministry has received representation seeking clarification on disclosures made under 182. So the 182 section of the Companies Act 2013, which came on 29th of August of 2013, said about the few disclosures. Now they are saying that in this letter which came just after, like it came in the August and just in the December, like 3-4 months, they are saying that the conditions have been removed. I'll tell what conditions. Companies contributing any amount or to an electoral trust company for contributing to a political party or parties are not required to make disclosures required under 182.3. Now we'll read out what is 182.3. So 182.3 read as follows. Every company shall disclose in its profit and loss account any amounts or amounts contributed by it to any political party during financial year to which that account relates, giving particulars of the total contributed and the name of party to which such amount has been contributed. So right now when we are discussing this, so we'll also discuss that who's at fault as well. Because when we discuss about the bigger picture, in the bigger picture we also discuss about the ruling party at that time and the ruling party of this time. So all the ruling parties were making the favors to themselves only. On 10th of December 2013 there was another ruling party, and before this letter as per the section 182.3 it used to say that whatever the amount, like we took an example, rupees 25 is to be contributed to a political party. So it used to be added in the financial statements and to which political party it is been donated. It used to be disclosed there and it was a public data. So after coming of this act, after 3 or 4 months, they said that you don't have to mention that data in your financial statements and it has to be a hidden thing. Why it has to be a hidden thing? Moving further. Company is contributing any amount or any amounts directly to a political parties which require to make disclosure laid down of the Companies Act. So they are saying you do not have to make any disclosures. Why you do not have to make any disclosures? We'll move further. I'll upload the link in my description to all the acts and all the references I am taking here. Moving further. So the game started to change in year 2013 as well. While we are discussing about the electoral bonds, we straightly tend to blame the current government or sometimes previous government. However, I'll say that both of these governments, like in the previous regime as well as the current regime, are being in the fault somewhere or else. Because in the 2013, why a letter had to be issued just after 3 or 4 months of the New Companies Act, when it took so many years to make a New Companies Act? After 1956, in the 2013, it took so many years the Companies Act came, and then you are making a letter to the Electoral Trust that no, the donations which are to be made under 182 section are not to be disclosed under the ROC, are not to be disclosed in the financial statements. Why is that? So this was the first game changer which came into picture on 10th of December 2013. Now the second game changer, which is the biggest game changer, that came in the Finance Act 2017. So the Finance Act did a huge damage when we discuss about that. So while we were discussing about the section 182 which came on 29th of August, so in the Finance Act they have omitted so many things. In the 2017 Act, the current regime, the current government was different than the 2013. So we'll discuss what changes did this government made. Moving further. So the Finance Act made so many major changes that you will be shocked. It has removed so many clauses. You will be shocked. Earlier there was a concept like they used to say notwithstanding any company other than government company more than 3 financial years, and then there was a concept of 7.5% as well. Then there was a concept that you have to disclose this as well. So they removed all three of these concepts, and now this is the final act. This is the current act right now, amended one, which has been amended in as per the 2017 Finance Act. I'll read it out for you. So currently now it says that notwithstanding anything contained in any other provisions of this act, a company other than a government company, the line is same, and a company which has been in existence for less than financial years may contribute, which has been in existence for less than, may directly or to any political parties. So it also used to say like this: has been in existence for less than financial, may contribute other than a company. So it also means that currently it's saying that other than a government company and a company which is in existence for more than 3 financial years can donate. Now it has omitted 7.5%. Now section 182 subsection 1, when we were discussing about the 7.5% proviso, it has been omitted, it has been deleted as per the Finance Act 2017. Moving further, that means that there is no concept of 5% now, there is no concept of 7.5%. This is not a big deal, I'll say, but the big deal is there is no concept of average net profits or net profits right now. So this is the main damage which has been done. So earlier in the 2013, when a letter was issued to all ROCs and RDs, they made it clear that no disclosure are required. That was also damaged. Where is the transparency? When we are discussing about the transparency, why to blame any government? You should blame every government, like the previous government as well as the current government. Even the previous government did this same thing. They did not made any changes to the major changes to the percentage. They just increased it by 2.5% from 5% to 7.5%. But why they have to hide a fact where the disclosure are not required to be made? Why it is to be done? However, in the current regime government, they have made many major changes, and they have I'll read it out. They have so in the current government, they have just made many major changes, and they have removed the concept of percentage. And this is a very small thing, the concept of percentage. However, they have removed the concept of net profits. I'll tell you how it is going to damage the transparency of the country. So moving further, what is the statement of the current government? I'll tell you. Earlier, when I took an example that in the 1956 Act, there is average net profit, and this is the rupees 10 you can give. Then we took an example of 2013 182 section. Then I took that 25 rupees and 5 paisa can be donated from the average net profits. Now the concept of average net profit has been done with. For example, you are earning 100 rupees. And the average is 100 rupees as well. I'm just taking, this is not final, I'm just taking an example. That means you can donate 100% of your 100% of your income, net income, to the Political party. Why you have to do that? Are you working for the political parties or you are working for yourself? However, there is no concept of profits as well. You can donate any amount. You can donate any amount. Now, for example, I'll take an example. There is a company A. A made a shell company B. B made a shell company C. A put 100 crore to B, B put 100 crore to C, and C donated it to political parties. Now C is a shell company. B is also a shell company. They are in existence for more than 3 years. That is okay. However, the money, it came through A as a loan, for example, or as any contribution, we'll say it was income or no income, it can donate to a political party 100%. That means that the regulation, it encourages the shell companies, and it also encourages the money laundering, and it also encourages quid pro quo. We have discussed this quid pro quo 3 times. Now we'll discuss it in some time as well. So why should a company donate 100% of its net profits? And not only 100% of its profits. I'll say what. Suppose a company having a net profit of rupees 100, or let's say a company is having a net profit of rupees 1, still that company can donate 100 crore rupees to any political party. This is the loophole which was brought by the current regime government in section 182. For example, you have just earned rupees 1. You can also donate 100 rupees, 1000 rupees, 1 crore rupees. And where is that money coming from? Because you just have rupees 1 profit. Moving further, these caps were introduced for some reason, like 5%, 7.5%. The caps were introduced for a reason, that the companies, why you make a company? To do a business. And why you have to donate 100% to a political party? That means you want a favor from the political party. So that means quid pro quo, something for something. You are paying 100 crores to political party and you are getting contracts from the government, to which you are paying, to whose political party you are paying. Moving further, so as per the government current regime, they said that this will discourage shell companies. However, I'll say this will not discourage shell companies. So what do you mean by shell company? So when we are discussing about shell companies, there is no definition of shell companies in any act in India. Not Companies Act, not Finance Act, not Income Tax Act, not Labor Act, not SEBI, nowhere. However, it has been discussed many times in case laws and in courts, but it's been discussed from so many years. Why can't you bring an amendment and just put the definition of shell companies? I'll read out to you what is the common concept of shell companies. An inactive company used as a vehicle for various financial maneuvers or kept dormant for future use. So when we are saying maneuvers as a vehicle, it means to money laundering. And when we say dormant, why it has been said dormant? Because in the concept of 182 section, it says that the company should be in existence for more than 3 financial years, then only you can donate. So that means that you need to keep your company dormant for 3 years, not working, so that you can use it as a vehicle to launder your money or to donate to a political party. So there is no specific definition of a shell company mentioned in the Companies Act or any other law. However, judicial decision in the Assam Company India Limited and another's versus Union of India, definitions in foreign statutes or literature are used to understand. Like from the foreign, we are picking the concept. Why we are not amending our own? So it says, it defines a shell company as a firm incorporated or organized or registered in the economy but does not take part in the economy operations. It means that you have created a company and you have just left it with zero expenses, with zero income, and you are just filing it return for years and years, and you are doing no business in it, no expenses made, no revenue generated, no wealth generation, no employment generated. That means a shell company which has been made and doing nothing. So in India there are so many shell companies right now as well. The business being, for example, there are Shell companies by choice and the shell companies by will, and the shell companies by force. We'll discuss it some other day. Moving further, we discussed that I'll revise it for you once again. We'll discuss in the 1956 there was a concept of 5%. In 2013 there was a concept of 7.5%. Now after the amendment in Finance Act 2017 there is no concept there, and you can donate any number of money by using anything, any method, or I think this will encourage shell companies only. So as per me, as per my experience of 7 years, and as per me being in practice for last 5.5 years, in these era, in these this is my core, I'll say that the act should be amended as follows. A company which has been incorporated in India, no foreign funding allowed to the political parties. This is my point number 1. Point number 2, having been incorporated for more than 5 financial years. So that the gap of 3 to 5 is 2 more financial years, so that you have to be more patient, and the current regime or a next regime government can also be changed in that time, which will discourage the shell companies indirectly. The company should be in profit for previous 3 financial years at least. Means that you should have profit for 3 financial years. It is not like you can have loss in 1 year and profit in another year. You should have at least profit in 3 preceding financial years. The maximum donation a company can made to a political party should be 15%. If you want to donate, let's say you don't want to go with the 5%, go with the 15%. A return should be filed with ROC in respect to same within 14 days of donations made. Point number 6, the company making donation should have independent director on the board. You want to make donation, more than 15% if you want to, up to 50%, more than 50% and up to 50%, then you should have independent director. Moving further, the donation return should be duly certified by 3 people. One is the director of the company, and the financials of the bank statement or the bonds should be certified by a chartered accountant. And the whole compliance, the whole form, the whole meeting structure should be certified by a company secretary, so that the check has been done on 3 different levels. Both CA and CS should generate a UDIN for this respect. So this was all about the background, the discussions which are going into the Honorable Supreme Court sessions. This is what is being discussed behind the electoral bonds, the transparency factors. Nobody discourages the electoral bonds. The discouragement is about the percentage being given to the political parties. That's all for the video. Thank you very much for watching. I hope you liked it. Please follow and subscribe, and please do comment. Thank you very much.